What's up, guys? Igor Hernandez here. Let's talk trial. Today we want to talk about jury trial in general. I noticed we put out a lot of trial tips as to how to do different things, and it's kind of aimed at different levels of skill and different abilities. But we never really covered what is a jury trial and what the actual steps are. I know some of you may have never tried a case, so this will be helpful to you. If you've tried a case, then feel free to ignore this video. But if you haven't, I'm gonna give you a breakdown today as to how it all works out. All right. So obviously, the first thing is different jurisdictions are going to do this differently. But for the most part, in the United States of America, this is kind of pretty standard. You may have some changes here and there, like some jurisdictions, the closing arguments a little different, or the order of closing arguments a little different. But for the most part, all of this is kind of standard. So what's a jury trial? First of all, a jury trial is a trial where the jury, which is just normal people selected from the community, decide the facts of the case and how the law applies to the facts. So basically, instead of a judge deciding whether the light was red or the light was green, a jury decides whether the light was red or the light was green. That's the most basic way I can put it. And how many jurors you get depends on your jurisdiction. Some jurisdictions do 6, some jurisdictions do 12, and things of that nature. But pretty much the concept is pretty simple. A jury from the community is going to come in and decide the case. So how does it all work out? Well, the first thing that happens really for the trial is you have to select the jury. So how does that work? Well, they'll bring down, the court will summon or will basically subpoena people randomly from the community. Usually it's either by the driver's license or by the voter registration, and the community or the people from the community will come down. Typically they'll bring down 35, 40, 50, depending on how big your case is. They'll come down, and depending on your jurisdiction, the lawyers may be able to ask them questions and see who's fair and who's not fair, or the judge is the only person that can ask them questions. It really depends on where you are. But basically they come down, questions are asked either by the lawyers or by the judge or both, and then you select the people that are going to be in your actual jury panel. Right, so the way it works out is when the questioning is done, then you select the people that are going to actually be sitting in your box. But anyway, so what happens is, based on the answers that the veneer gave, you can strike, you can get rid of certain jurors. And then you have some what's called peremptory challenges, where you can get rid of some other jurors for whatever reason, so long as it's not based on race, sex, or things of that nature. So whatever, you basically, all the questions are asked, you decide what jurors you're going to kick off, the other side decides what jurors they're going to kick off, and then you end up with whatever jurors are left over that were not kicked off. Typically it goes in some sort of order. Some judges do it in order of numbers, because the jurors, when the veneer sits, they'll be assigned numbers. And other judges do it randomly by pulling cards or flipping coins or whatever. But bottom line is, you end up picking the people who are still legally able to sit, and then you end up picking as many as you need to sit. So if it's a 6 juror jurisdiction, you put 6 in the box. If it's 12, you put 12 in the box, and so on and so forth. And then there'll be some alternates. So the judge will select either 1, 2, or 3, depending on the length of the trial, to sit just in case. Because if one of the jurors is sick, one of the jurors dies, or whatever, you want to have a backup, basically, somebody that can step right in and keep the trial going. So after the jury is seated, they'll be sworn in to actually hear the case, and then the first thing that happens is opening statements. The prosecution or the plaintiff will go first, the defense will go second, and then after opening statements, the actual case is put on. The prosecution or the plaintiff puts their case on first, the defendant puts his or her case on second, and then the prosecution or the plaintiff gets what's called a rebuttal case to basically put on some witnesses to address things that came out in the defendant's case in chief that was not foreseeable to be addressed on the plaintiff's case in chief. After the plaintiff puts on their case, there's some motions that can take place, motions for directed verdict or judgment of acquittal on the criminal side, and basically that's the opportunity for the judge to look at all the facts and taking those facts in the best light for the party who's not doing the motion. So in the best light for the plaintiff, the judge can decide if a reasonable fact finder could find for that party. So basically, even if everything the plaintiff is saying is true, taken in the light best for them. Do they have a case or do they not have a case? And if they don't have a case, based on everything taken in the best light for them, then the judge could kind of get rid of the case at that moment. So anyway, let's say the judgment of acquittal or the directed verdict is denied. The defendant puts on their case. Let's say there is no rebuttal case. Then there can be renewed motions for directed verdict or judgments of acquittal. And then you go into closing arguments. Typically, the plaintiff or the prosecution will start the closing argument. They'll go first. The defendant gets a closing argument. And typically, the prosecution or the plaintiff gets what's called a rebuttal closing argument. And legally, in theory, the only thing that the prosecution or the plaintiff is supposed to be able to address in the rebuttal are the points that the defense brought up. So it's supposed to be kind of a counter argument to whatever the defendant put on. Then after that, the jury is instructed on the jury instructions, and they go deliberate, and then that's pretty much the end of the case. Things that are kind of missing from that presentation is at some point they do like the jury instructions conference, which some judges do it in trial, or the judges do it before trial, or the judges do it after trial. It really depends on how they want to play it, but it's basically a time where both sides come together and see if we can agree on what the jury instruction should be that should be read to the jury. If that happens, or when that happens, basically all it is, the judge asks both sides to submit proposed instructions, and then the judge will go through them and say, okay, do we have an issue here? Do we have any objections? Can we all agree? That kind of stuff. And ultimately, if there are any objections, the judge will decide which jury instructions are going to be given, even if a party disagrees with that interpretation. At the end of the day, the judge is the judge, and he or she makes the call. And then other things that are missing, sometimes the jury asks questions during deliberations. So they'll send out a note that says, you know, can we hear this evidence again? Or what about this point of law? Or can we do this? And things like that. And you may be called into the courtroom to basically go over how that question should be answered, if it should be answered, and all those kinds of things. So that's pretty much it. You know, there's some pretrial stuff that happens, like motions and limines and stuff like that. But that's you know, another conversation for another episode. And that's, you know, that's in a nutshell, that's how jury trials go. So that's pretty much it, guys. I'll catch you next Wednesday. If you like the video, hit the subscribe button, hit that bell, the notification bell. That way you can see the new videos when they come out. And thank you for watching. Catch you later.